Good afternoon, everyone. Thank you for joining us this afternoon for this Bristol Law Society webinar. This is an introduction to mediation and arbitration in family cases, and we're kindly joined by His Honour Nick Marston and Julia Smarts this afternoon. Julia is going to kick the session off by speaking to us about the benefits of mediation, and giving us some food for thought around that. And then His Honour Nick Marston will speak to us about arbitration, and it's going to be a thoroughly interesting next hour. So just some housekeeping before we get started. There is a Q&A box if you're able to add any questions that you've got to the Q&A box rather than the chat. That would be much appreciated, and we will have a Q&A session at the end. There will be a recording made of this session, and the link for that, along with some notes from His Honour Nick Marston, will be shared after this session. So I think that's everything from me for now, so I'll pass over to Julia.
Well, thank you very much for inviting me, and hello to everybody. Until I retired as a solicitor last December, I'd worked in family law for 40 years. I qualified as a family mediator in 1997 and joined Bristol Family Mediators Association, and from then on was regularly mediating with people from all walks of life. And I also worked as a collaborative family lawyer from 2006. The attraction for me in both mediation and collaborative practice is what I consider the frankly logical approach, that for a couple to sit down together, having their lawyers for support and guidance, rather than taking up the cudgels for them, in order to look for a mutually fair and acceptable solution, is a much better idea. And in all these things, communication is absolutely key. My experience both as a family mediator and as a collaborative lawyer is that where there's a relationship breakdown, the first step should be an opportunity for people to talk freely to see where the resolution can be reached. I suspect that if I asked anybody in a functional relationship what they would hope to do if things went wrong, it would be to sit down and talk about it, rather than run off to a lawyer and become embroiled in all the court process, and not to mention being faced with bills for tens of thousands of pounds at a time where really they'd do much better for keeping the money to transition and set themselves up in their new situation. Mediation can be used at any point in the dispute, but it's particularly useful if it comes in early on. Often we use it where it's not even known if there is a dispute. I have plenty of couples who come to me because they basically haven't got a clue and don't know where to go, what to do, or what to expect. I find that people going through relationship breakdowns tend to have a rather pessimistic outlook, usually because they're frightened or worried, and they're much more likely to catastrophize and expect the worst. Getting them together at an early stage so they can speak openly about their hopes and fears, and to enable them to see the position of the other person, is much more likely to result in a constructive arrangement where they feel in control of the outcome. I also feel very lucky to have the experience of being a traditional family lawyer, as it's opened my eyes to some of the unconscious biases that we may have, and also our desire to solve our clients' problems with our solutions. With mediation, I always have an initial one-to-one appointment with each person first. And however open-minded I like to think I am, after I've spoken to the first person, I will always have formed a view of what I think the other person might be like before I've even met them. And I have to say, it's very rare that they actually fit that profile. Once you've met with both people, it's so much easier to understand what the potential dynamics are. And the benefit of working through mediation is that I'm in a position to help both clients have some understanding of the other person's fears and priorities. And perhaps this can give them a bit more insight into why that person is taking the stance that they are or behaving the way that they are. The other point is that working as a solicitor, the client presents the problem and then the solicitor racks his or her brain for the solution. The reality is that the two clients are very much better positioned to find the right solution for themselves and their family, because they'll be able to factor in their own values, their sense of fairness, and can come up with a solution which will fit their bill, which probably no solicitor could have thought of for them. I had one case really early on when I'd qualified, which to be honest was an absolute gift as it turned out. It was a couple who, where the wife had been married before and had a 12-year-old daughter. The husband was an estate agent and he had joined that estate agency when he was 17 and was extremely proud of working his way up through it. And although the couple weren't particularly antagonistic towards each other, they both felt the situation was completely hopeless. So by talking things through with them right at the start, it became apparent that the wife's only real concern was that she didn't want to have to leave the house because this would disrupt her daughter again. And it had happened before and had not gone down well with the daughter. Meanwhile, with the husband, rather bizarrely, he was completely wedded to his pension, which he'd been paying into since he was 17. And he was extremely resentful that he might have to share this well-earned wealth with his wife. So, as luck would have it, as soon as they both expressed their fears to each other about what they had each considered as a hopeless situation, it became perfectly obvious that there was a very simple trade-off of the house against the pension. And I have to say, that was an absolute gift that day, because it was resolved in an amazingly short time. And both clients were extremely happy and extremely relieved. I mean, obviously, they probably have got to the same place going down the traditional route, but I'm absolutely certain it would never have happened so quickly. And it was because you are in a position to have that open conversation so early on. Having said that, I absolutely acknowledge that mediation isn't always the right way forward for everybody. There are situations which we'll come to where it really isn't the answer and could potentially cause damage. And obviously the trick is to spot these right at the outcome. I'd also say as a mediator, it's really helpful for me when clients have a solicitor as backup. It enables them to revert to the solicitor during the process, either to use them as a sounding board or to ask them for guidance. And then the client can come back with a much clearer view of what they want and maybe some questions that they can ask us to work through in the session. So coming to the basics of mediation, it's voluntary. It's a confidential and legally privileged process, which gives the parties a chance to discuss their issues, their hopes, their concerns and needs with each other. And they can do this in the presence of an impartial third party who can guide them through. It provides a really safe environment because of this confidentiality, and this will usually help reduce the hostility and improve the chances of long-term positive communication. As a family mediator, I don't advise people what to do. I don't give them legal advice. I obviously don't take sides, and I don't provide counselling, although I can refer them to people to do all those things if they need it. I can, of course, provide them with information, which will include what the law says, or sometimes how other people have dealt with similar situations, which may help them move along. Mediation is a place where you can sort out nitty-gritty matters around family finances or children arrangements, but you can also sort out much broader issues such as communications or aspirations for how they want to function as a successful separated family. And in fact, anything else that they feel will be helpful to the transition to their new setup. So the benefits of mediation are undeniably it's cheaper and it's quicker. But I think it's much more likely to maintain a positive relationship for the family going forward. It's an opportunity for both people to hear and be heard in a safe place. And it also means that the clients can retain control of their decisions and outcomes. We can also pace the process to what the clients need. So sometimes we have to go really fast if, for instance, a house is just about to be sold, or we can slow it up if people need time to reflect or to get information. And fundamentally, we're focusing on what people's driving interests are, rather than getting caught up in minutiae or being proved right. So how does it work? It always starts with a MIAM, Mediation Information and Assessment meeting. And the purpose of this is so that I can explain to the clients how it all works and answer any questions. I can also deal with screening. So it's really important that I can have an opportunity to make sure that there's nothing underlying which might cause us issues, make sure that the client feels able to speak about fears, particularly where there might be domestic violence or mental health issues. It's an opportunity for me to gain their rapport and also hopefully their confidence that the whole process will be impartial. And finally, it's a place where we can discuss how best to prepare for the joint session. Generally, it takes 45 to 50 or 60 minutes. At the end, if they don't want to go ahead or it's clearly not suitable, then I can issue the mediator certificate, which is typically page 9 of the C100 or page 12 of the Form A. But more often than not, it goes ahead, and then I will have the same meeting with the other party to prepare them as well. Mediation is suitable for couples, whether they're married or unmarried. It's suitable for parents and children, for grandparents. I've done it with sibling. Basically, any relationship where there's an issue that needs to be resolved is perfectly fine and within our remit. So turning to when it's not suitable, obviously it's not suitable if clients don't wish to engage with it. It's also not suitable for clients with mental health issues, or if they've got some unchecked addiction issues. It's not suitable for people who aren't prepared to disclose or engage in the process effectively. And it's certainly not suitable where one party uses the process as a platform to abuse the other. So hopefully you screen these things out right at the start, but if going through any of those things come to light, that would be a reason to bring the mediation to a close. Domestic violence in itself is not a bar to mediation. And in fact, since we've been doing so much more by Zoom, it's clear that there's quite a lot of situations where it wouldn't have been suitable around the table, but it's perfectly fine by Zoom. If there's any issue of domestic violence, then clearly we need to check much more carefully that going forward in this way isn't going to put anybody at risk, either emotionally or physically. Generally, I find if the domestic violence is a controlling behaviour sort of matter, it's unlikely to be successful in mediation, and they probably are better off going down the more traditional route. So once we've got past the MIAM, then we come to the joint session. I find probably we average for most people 3 or 4. So at the first session, we set the agenda, and the agenda can be as wide or as narrow as they wish it to be. The next thing is to build up information. So in financial matters, we start as early as possible with getting together the asset schedule, and we work our way through it so that we can check that it's agreed, and if it's not and understood. So sometimes we need the parties to explain the figures to us. And we also check whether there's anything we need, like a valuation or further evidence or explanation from anywhere else. And by building on the asset schedule, the idea is by the end, both people are absolutely confident that it's comprehensive and reliable and will be able to support the final arrangements. So from a practical point of view, we do require supporting evidence to make sure that the whole system is robust, but we only need sufficient evidence. So I'm not looking for reams of statements of things which are uncontroversial. Once we've got together all this information, we then focus on the joint resources and what they look like. And that will include things like their mortgageability, earning ability, and also what they each wish to achieve in broad terms. The next step is basically trying out different ideas to see how the resources that are available will fit their wishes. And if we can find a solution that logistically fits the bill, then the next step is to check whether that particular arrangement is going to be fair. And sometimes it isn't. So then the final stage is to find a way of adjusting things to make it fair, which is typically having a chargeback or a trade-off of some pension. So having got to the end of the process, I can draw up the summary in the form of the memorandum of understanding, and where there's finances, there'll also be a financial statement to support that, and which can also go forward and be part of a statement of information to be submitted to the court with a consent order. The memorandum itself is not a legally binding document. So for most people, particularly with the finances, they will take it to their solicitor, who can then extract the relevant bits and put it into a legally binding format, usually a consent order or a separation agreement, or maybe an exchange of letters formally. Moving on to children, I think that the mediation process is ideal for dealing with children issues, because it's so much more conducive to helping the parents work out together how to co-parent as they transition from being a couple to a separated pair of parents, which is quite a tricky thing to do. I find that because children are so emotive, parents can come into mediation with very black and white views, which are often quite unrealistic. And because we take a very practical approach to this, it's just focusing on how things will actually work in practice. So it's very common that people will come in saying that they've got to share the children's time 50-50. And rather than challenging that, it's a matter of looking to what's going to happen on a daily basis, how they're going to deal with the inset days, what are they going to do if a child is ill, or if their meeting runs over, or they've got to travel for work. And very often, by actually looking at the practicalities of it and how it's going to look from the children's point of view, you find that parents can come to quite a sensible arrangement, because I think they're not feeling threatened or challenged, but they can just see that they need to think it through. I can also help them understand that with children arrangements, they aren't written in stone. They need to be reviewed regularly, and they need to be adjusted to take account of changes that happen in the family's lives. And that, I think, helps them understand that their cooperation with the other parent will be crucial to happy children and sustainable arrangements. So the next area that you may or may not be aware of is the child inclusive mediation, which is a relatively recent evolution. And this is to give children a voice in the process. The way it works is that children who wish to be heard, or if parents feel that the children have got views which are not being listened to, they can ask for the child inclusive mediation to take place. It needs everybody involved, so the children and the parents, to consent to that. And the children will have exactly the same confidentiality that anybody else would in mediation. Typically what we do then is involve a second mediator who's experienced with dealing with children. The parents will sign a consent form, which also confirms that they won't coach the children, they won't interrogate them about it, and generally that they will allow the children to have the freedom to speak. And the parents are told that the children have the confidentiality so that they won't necessarily hear everything that the children have to say. Once we've gone through those formalities, that mediator will meet with the child or children, and it can be done remotely. Sometimes it's done face-to-face. Quite often it happens in the school so that there's a neutral place for that to happen. And the mediator will explain to the children that she or he is there simply to hear what the child wants to say, and that they will take back to the parents as much or as little as the child wants them to do. And once that's all happened, then we have a meeting very quickly after that session where it will be the parents, the child mediator and myself, and we will have the feedback so that the child mediator simply feeds back the messages that the child or children have given without comment. It's simply feedback, and then they withdraw from the process. And we will then continue, so with me and the two parents, now discussing the children arrangements, bearing in mind what we've heard as the voice of the children. And it seems to be a very powerful and sensible way forward. I think the other thing some people think is that mediation isn't suitable for complex or big money cases. I disagree with that because I think it's quite often very suitable. The difference where it's complex or big money is we may need to bring others in. And I quite often find it's helpful working with financial planners who will be in a position to meet with the couple. They're infinitely better equipped to prepare a full and comprehensive asset schedule, often to explain it to the clients who may not completely understand what their finances are, and to then give advice on how they could deal with matters, but in a neutral way. And I think being able to work in that fashion, where both clients are getting the same information from the same person, can be a much more productive way of going forward. In other cases, we've brought in accountants who can perhaps explain difficult things like company setups. Haven't done it yet, but if there were a difficult bit of law, we could bring in a barrister. So I think the answer is, with complex and big money cases, absolutely no reason why it can't be dealt with through mediation. But in those circumstances, we probably need some help on board. And then lastly, the other model that you may or may not have heard of is the hybrid mediation model, which is where family mediation takes place, but it's attended by both parties' solicitors. And that model is very much closer to the civil and commercial model, where you often do a bit more shuttling, and it works slightly differently from the model that I do and that I've just explained. So for me, mediation provides a really practical way of looking at the issues to be resolved and working through them with the clients to achieve something that both people feel that they've agreed and they've actually bought into going forward. And at the end of the mediation, many clients have already been able emotionally to move on and accept the new lives that we're setting up for the family. So for me, it's a really powerful way of working, and I have to say I wish to continue it for as long as I possibly can.
Well, I think it falls to me now to talk to you about arbitration in family cases. I'd like to thank Bristol Law Society for asking me to do that. the Bristol Law Society is an institution that I have a great deal of respect and affection for over a great many years. Much the same comment can be made for my co-presenter today, Julia Smart, somebody who I have enormous respect and affection for, who's been a colleague of mine for 40 years or so, and has, I think, made you very aware of the positives of mediation. Smart mediation, she calls herself. It's a name and a mission statement and an endorsement all in one sentence. Now, for those of you who thought you'd seen the last of me in November last year, I am very sorry, but it was either this or golf, and really I do hate golf. So I thought I would take up a third career as an arbitrator. We'll start off with the definition of arbitration. My note for all of this will be available from BLS in about half an hour after the end of this webinar. Some of these concepts you may not be as familiar with as with, for instance, mediation. So I thought it would be helpful for you just to have a note to refer back to. Definition of arbitration then. The process of solving an argument between people by helping them to agree to an acceptable solution. Both sides in a dispute having agreed to go to an arbitrator to have that disagreement solved by an arbitrator. That's the Cambridge Dictionary's definition. For our purposes, I rather prefer this rather robust American dictionary definition. The formal process of having an outside person chosen by both parties to a disagreement to end that disagreement. Looking at the history very shortly, the history of arbitration really, from a legal perspective, starts when European countries in the 15th and 16th centuries began to venture out onto the seas, first of Europe and then later all over the world, to trade. And there were disputes about spheres of influence, who could trade with who, what currency you got paid in, and so on. A system arose whereby the two countries or the two companies or the two people involved would appoint an arbitrator to give a decision. Over a period of time in the 17th and 18th century, the use of arbitrators grew immensely in commercial area, insurance, and in particular in shipping law, where there wasn't a court that had jurisdiction over both of the parties, so arbitration became standard. In the 60s and 70s, arbitration in this country was extended in particular to industrial relations and agreed pension rights. So in many areas of the legal system, the concept of arbitration was a standard option. However, in a family dispute context, it's only since the 22nd of February 2012 that arbitration has been available in family law. It's important to understand that arbitration is a completely different process to mediation. As you've already heard, mediation helps the party to reach an agreement, which is facilitated with the aid of a mediator. There are some cases, however, where mediation is not possible. Sometimes this is apparent before mediation process starts, and sometimes it becomes apparent during the process itself. Not all of these disputes are capable of being arbitrated, but many are. Since the 22nd of February 2012, until the 22nd of February 2012, the only way for a dispute to be dealt with in a family case, if it couldn't be mediated, was to go to court. Going to court, both in financial issues and with regard to private law children applications, has, in the last few years, become more and more difficult. The problems, as I perceive them, arise out of the sheer volume of work that is going through the court system. I can only speak of the position with regard to children cases until the end of last year, and I mean no disrespect whatsoever to my hard-working and desperately overstretched colleagues in the judiciary who are run off their feet by cases. But the resources available, both in terms of court time, matching the appropriate judge to the case concerned, and then keeping continuity of that judge on anything like an acceptable timescale, are becoming more and more difficult. You've all been there. Anybody who's a court user has been there. Delay, multiple adjournments, changes of judges, cases overrunning into multiple days because you don't get on until the afternoon after the judge has labored his way through the 6 care directions in the morning's list, and so on and so on. The last 12 months or so have seen this position, in my view, get worse simply because of the backlog of care cases due to the pandemic. There's virtually no space in circuit judges' lists for doing private children work and very little space in district judges' lists. Inevitably, this means waiting a long time to be heard, lengthy adjournment dates, and a great deal of cost to the parties. There's a lack of choice in terms of the way you deal with the dispute. One size is stretched to fit all. It may well be appropriate. Rather than cases therefore go forward to arbitration. The point is sometimes made against this, that this will lead to a two-tier system of justice, that those who pay go private and those who can't are confined to the state system. I would very much like to see the system properly resourced with public funding for most people and judicial and court resources amped up to cope with the number of cases. After all, it's a system I worked in for 46 years, but this is not going to happen. The latest figures show that over the country, in the 3 months up to September 2021, the average length of time for a private law children's case has gone up from 28 weeks pre-pandemic to 42 weeks. There are also enormous difficulties in appointing judges, with in particular huge numbers of vacancies at the district judge level. 70, I understand, on the southeastern circuit, and a number on the western circuit that have not been fulfilled as well. The President has supported alternative disputes resolution for some time, and that includes arbitration. The DFJ for Bristol, always a very quotable source, actively encourages it. Inevitably, there's even now a two-tier system, with those with money and those without. Let's at least make the system work. Arbitration will take some pressure off the courts and also secure better outcomes because of the way it's conducted in appropriate cases. Family arbitration, what are the options there? The Family Law Arbitration Scheme was launched by the Institute of Family Law Arbitrators, the IFLA, which is a not-for-profit organisation created by the Chartered Institute of Arbitrators, Resolutions, and the Family Bar Association, together with the Centre for Child and Family Reform. There are two arbitration schemes which run financial and property matters. That was the one that started in 2012. And now, from 2016, there's a children's scheme as well. They're both governed by the Arbitration Act with their own particular sets of rules. The governing law for arbitration under these schemes is that of England and Wales, and the parties can't contract out of that, but they can tailor procedures to fit the case and the scope of the arbitration, and they can also fix the identity of the arbitrator. How does it work then? I thought it might be helpful to go through a case in arbitration, and the first thing to point out is that the case has to be suitable for arbitration. Arbitrators are not allowed to deal with child protection issues. So, for instance, all cases of physical and sexual abuse allegations are not capable of being arbitrated. Neither are cases of domestic abuse allegations. An arbitrator cannot, for example, make findings of fact about these sorts of issues. If child protection issues arise during the course of an arbitration, for example, if somebody starts at a point in a hearing making allegations about child safety or physical abuse or whatever, the arbitrator has to stop the case and refer the issue to the local social services department. I should also point out that vulnerable parties and persons under a disability will find that arbitration is not appropriate for them. In particular, they regard their ability to provide informed agreement to arbitration. However, there are many cases where arbitration is appropriate. Most cases where the parties are in dispute about child arrangements and do not have safeguarding issues. We've all encountered these sort of cases where the parties simply can't agree about how to proceed over some issue. For instance, how much time the child will spend with each of the parents, or what agreed arrangements which were appropriate for a child of 4 or 5 should now be varied when they're 11 or 12. There are also cases about reallocating to another part of the country, where issues of how to reframe the amount of time that each of the parties spends with the child are intractable by the parties themselves, both parties having perfectly reasonable grounds for saying, I want to see more of the child. These sorts of cases are resolved by arbitration, as are virtually all disputes about education, some disputes about minor health issues, and a great many disputes about removal from the jurisdiction, either over holiday issues or even on a permanent basis. And because, of course, arbitration can be dealt with much more quickly, as I'll show in a moment, they're particularly helpful for those sorts of time pressure disputes. In most cases where arbitration is suggested, I suspect it will be suggested by the party's solicitors early on, or it will be after an attempted mediation has failed. There will obviously be some litigants in person who prefer to go to an arbitrator or a judge. I'm not going to talk about that. I'm going to talk about things where solicitors are involved. One, as an arbitrator, has to be very careful where you're dealing with litigants in person. The first step is that the parties sign an agreement to submit to arbitration, accepting that the decision will be binding on them. The process itself is private and privileged, so that it's exactly the same as going into chambers in court hearings. It might be useful for me to set out the basis of an appeal from such a decision at this point, because I know that the parties sometimes are very concerned about that issue and need to be fully appraised of the realities of the matter. Once you've arbitrated, you can't go back to a court and ask for a redetermination. Under the Arbitration Act, an award or determination can be challenged if the award is made without jurisdiction under Section 67. If there's been a serious irregularity that has caused or will cause substantial injustice under Section 68, or where there is an appeal on a point of law under Section 69. Challenges under these sections can be brought within 28 days of the date of the award or determination. I'm not going to say very much more about this, except that you will note that this in reality is not much different now to the provision of an appeal from a court decision in a family case. The recent trend in cases about appeals in arbitration is to widen the ability of the court to look at an arbitration, so that my own view is that you are just as protected against an incompetent or ill-informed arbitrator as you are against an incompetent or ill-informed judge, and that a court will intervene if things go badly wrong. But the number of times when they do go badly wrong is very limited because of the sort of cases that you're dealing with and the fact that everybody is buying into the arbitration. Your two lay clients have agreed to arbitrate. And if it's a children arbitration, they also have to provide you with details of safeguarding information, which is usually by way of a police check with regard to safeguarding issues. You must also agree the identity of the arbitrator. There's then a scoping meeting between the two solicitors involved and the arbitrator. This will usually be conducted by Zoom. It's not charged for, and there's a short discussion where the two parties' lawyers indicate to the arbitrator the nature of the dispute and the issues involved, and the arbitrator either accepts or rejects the case. If he accepts the case, the seat of the arbitration is set. What's meant by that is that if it's an arbitration which is going to take place in Bristol, the seat will be Bristol. If it's Bath, the seat will be Bath, and so on. The reason for that is that where the seat is sets the governing law for the arbitration. It's the law of England and Wales, and in our area in particular, it's the Children Act and all the decided case law around that. This is relevant in a number of cases, obviously where there are issues of law to be considered, as for instance in removals from the jurisdiction. But it's also particularly relevant to the parties with regard to costs, because almost inevitably in arbitration costs, the cost adjudication will be that each party meets their own costs, as it is, of course, in the case in most family cases in any event. So that setting the law means that we all follow a very familiar path that is known to all of us, and that we deal with in court as well. If the case is very straightforward, let's say, for example, it's a discrete issue about child visiting time, then it may be that the parties can agree that it can be dealt with by way of written submissions. At the scoping meeting, the arbitrator will then set a date for the submissions and a date for handing down his arbitration. You may think it's necessary for there to be evidence from the parties. You can discuss issues about how that would be put forward, usually by statements. At this point, you may also decide that the case is getting a bit complicated and you need to have a proper appointment with the parties there so that people can take instructions and deal with matters in much the same way as one would do in a directions appointment. That appointment can be arranged fairly quickly. The other issue to discuss, and I was very interested in what Julia was saying about the child mediation, because it's particularly relevant here as well, is the voice of the child. Arbitrators are not allowed to see the children. Therefore, the children's views have to be canvassed by some other way. And of course, one doesn't have CAFCAS to call upon. What normally happens is that a short independent social work report is commissioned, which is essentially the wishes and feelings of the child report that we're very familiar with in CAFCAS cases. As I've said, getting into discussions about these sorts of issues, I would expect you to need your clients there. So the scoping hearing will either be a 10-minute hearing with which sorts out all the issues and then proceed straight to the arbitration, or it'll be a very short hearing in which everybody decides need the parties and have a proper discussion of how to deal with evidence and issues. That will then become the first attended hearing, in effect a short directions appointment at which the evidence is considered and so on. That again can be a remote hearing to be timed convenient for everybody. Then you've got a lot of options as to how you set your final hearing. Is it going to be by submissions with the parties there, limited evidence being called, either by the parties' statements and them saying something to the court, or are they going to be cross-examined, or are you even going to call supporting evidence either by way of statements or by way of live witnesses? The nearer you get to an orthodox court hearing, the more concerned the arbitrator is going to be about whether the arbitration is still appropriate, because you've got to remember that we cannot deal with certain issues. If cross-examination does occur, the arbitrator will focus it on the issue that is being arbitrated. Sometimes the arbitrator will ask the questions. It depends on issues and depends on the views of the parties in a discussion. If witnesses are to be called, it's more likely that they will give evidence by statements rather than being examined and cross-examined. However, again, there is scope for focused cross-examination in arbitrations. The arbitration hearing itself is one which can take place either remotely or at a neutral venue. At this hearing, the procedure is very close to that of a court hearing, but I hope a little more informal. It helps to work out what everybody is going to be called beforehand. Once the arbitration is dealt with, if I was doing it, I would say I will now produce my arbitration in writing, which will contain at the end the award, which is effectively the decision, which can then be converted into an order to be filed in court. In my experience, all courts on this circuit will happily make such orders and enforce them. Of course, the arbitrator can't enforce the orders. It's not uncommon for the parties not to go to court and to just to have it as an agreement between them. You've got to remember that the parties have elected to go to arbitration, and that indicates that most of the time they will be prepared to compromise once that arbitration has been made. It's important to stress to the parties that at no time, once the process is engaged, should they seek to contact the arbitrator direct if they're represented and they're able to withdraw from the arbitration process at any point during the process, although of course issues about costs arise then. Briefly then, what are the advantages of arbitration over court hearing? First of all, it seems to me that the timescales are radically compressed compared to the court process. The arbitrator is only concerned with your case, so you have continuity. I would expect from the agreement to arbitrate, virtually every case could be dealt with within 6 to 8 weeks, and that would be subject to parties' diary arrangements and possibly subject to getting that independent social workers report. The hearing will be focused. The cost of the process are agreed from very early on. The usual practice is that the parties will meet the costs 50-50, so that we will not get those truly horrible situations of arriving at a final hearing and one of the parties has run out of funds and legal representation prior to that hearing. There will be some flexibility in terms of the arbitrator's costs once they're set. For example, if an arbitration takes less time than was expected or agrees before the final hearing, I'm certainly a person who would be open to suggestions then that there are significant reductions in the set costs fee. Obviously, on the other hand, if issues arise which cause a hearing to have to be abandoned or rescheduled, then it may be that something extra will have to be added to the fees. The main point in all of this, as it is in mediation, is that the parties have more ownership of the process. Julia used a phrase, they've actually bought into it. Well, they've actually bought into it, not just metaphorically, but in reality as well, because they have paid upfront for this and they have elected to do it. I hope that because of the nature of the process, it will be less damaging to the parties and the children concerned than is sometimes the case in private law proceedings. I've spoken about children cases because that's the area that I'm arbitrating, but virtually everything that I've said is applicable to financial cases, which are, I suspect, even more susceptible to arbitration than children matters. I hope that in some cases, arbitration will lead to a speedier, cheaper, and less corrosive outcome for both parties and their children. This is an idea, as they say, reaching for a cliche, whose time has come. Thank you all very much.
Thank you so much to both of you. If anyone has any more questions at this stage, can you add them into the Q&A box now? Julia, how are you seeing much interest, or how much work are you doing around the child-led or child-inclusive mediation? Is it quite popular?
It is quite popular. I think there are some parents who then are reluctant to pay the extra for the second mediator, because clearly that's a sort of additional bit that they hadn't necessarily budgeted for. But certainly I've got a number going on at the moment, and actually I find it's really, really useful because it generally does flash out feelings, and often children will be saying different things to each parent because they're sort of riding a tightrope, and so to give them an opportunity to speak to somebody is great. And it's very difficult really for a parent to argue when the message has come back very clearly from the child. And so usually, I say apart from one case, it really just made everything so much simpler because the child had spoken and everything had to be geared to what he wanted.
Yeah, if I can say that sometimes the effect of the independent social workers report is exactly the same in arbitrations, and the case, once people see what the child is saying or the children are saying, the case then settles.
Thank you both. And one of the questions that's come in is around the minimum age, or is there a minimum age for children in that kind of process?
No, I think it's a bit like everybody sort of seems to think 10 is an age, but often if you have sibling too, then you certainly wouldn't exclude one. You might perhaps treat, you know, that the person speaking with them would talk to them differently, and you might not put so much weight to what they were saying, but you would be very careful, particularly if there were a sibling, to make sure that all of them are on board. And generally speaking, the mediator will speak to them as a group, and usually we'll try and speak to them individually as well, because again, you can find some siblings are sort of protecting a parent, or even trying to align with a sibling when actually they don't agree with them. So it's quite a careful dynamic, but sensitively done, you know, it's just brilliant.
Yeah, I think it's yeah, a really helpful mediation style to be able to bring the children in that way. Thank you, Julia. Nick, in terms of your work as an arbitrator, so far, how have you found the kind of split between, or is there much of a split in your work between children and money?
Well, I don't have a money ticket. I took the view that over the last 15 years, well, I used to do it a lot when I was in practice. Over the last 15 years as a judge, I did virtually none, apart from bizarrely the occasional appeal. And I took the view that things have changed so much. But I actually think up until recently, there has not been much child arbitration. People are much more used to going to arbitration with financial hearings. The position with finance is, after all, not that dissimilar to having the usual process for financial hearings. The issue resolutions, what's it called now? I can't remember. The not the IRH, the
financial dispute resolution.
Sorry, the FDR. I told you it's a long time since I've done it. The FDR is in many ways an arbitration, and it's much more. I think the idea that you can go to court over children, you can go to the arbitrator over children's issues, is one that is only gradually sinking in now, and I think that the two aspects of it: first of all, it's only been in for 6 years, and secondly, I have to use the word very carefully, the state of the current situation in terms of court hearings are two big imperatives behind this, and people are gradually getting used to the idea. So it's a long, convoluted way of saying that financial arbitration is very much part of the course, whereas children's arbitration is still in its, oh dear, I was going to say in its infancy. I don't mean it like that. Yeah.
Thank you, Nick. Thank you. That's really helpful. I think that's all of the questions that we have for today. So that leaves me with saying thank you very much to you both for a very informative session. I think the real takeaway is definitely around ownership for our family clients, in terms of having a bit more control over the timings of the process, and you know, keeping things outside of the court process as well. So thank you all for joining us today. It'd be really helpful if after the session that you're able to complete a feedback form, which I believe will come up when you leave this session. If you'd like to join some more of the BLS webinars, you can find details on the website, and also on the social media feeds. This will also be on the recording will be on the YouTube channel as well. So thanks to you both again, it's very much appreciated. Thank you for your time, and hope everyone has a good rest of the afternoon.
Thank you very much.
Thank you very much.